start with just briefly introducing you.
Okay. My name is Lucas Reckziegel Weschenfelder. I'm Brazilian. I research data protection and legal theory, and I'm going to present a paper entitled "A Museum of Great Novelties: The Risk of Unified Identification Number for Citizens in Brazil." Yep.
Hello, my name is Elif Beyza Akkanat. I'm from Istanbul University. I am working at Comparative Law Department in Istanbul University as an assistant professor. And today, with my colleague, Professor Yücedağ, we are going to present a paper about interaction between data minimization and the consent.
Hello, my name is Nafiye Yücedağ. I work at Istanbul University at the chair of civil law. As my colleague Elif Beyza has mentioned, we will today briefly explain the interrelationship between consent and data minimization principle, especially reasonable alternative test. That's how we call it.
Good afternoon. My name is Evrim Görmüs. I'm currently a Jean Monnet Fellow at the European University Institute in Florence. I'm also Associate Professor in Istanbul MEF University. Today I will talk about the digital authoritarianism in the Middle East.
Hi, everyone. Can you hear me? Yes. My name is Beatriz de Souza. I work in São Paulo at the Lawgorithm Research Association, an association focused on issues on law and AI, and I also work as a lawyer in antitrust. So I'm going to present a paper about lessons learned in antitrust merger control on digital markets and their application on AI markets.
Thank you for presenting yourself. So it will be that we have 10 minutes per presentation. We then have 5 minutes Q&A, and then afterwards we still hopefully enough time for 50 minutes of general Q&A. So I'll give the floor to Lucas Reckziegel to give the first presentation.
Okay. Thank you. First, I'd like to say that it has been a great experience for me to attend in this Congress. It's my first time. I'm a PhD researcher, and thank you all for being here today to hear us and to discuss the subjects. So, like I told previously, my paper is entitled "A Museum of Great Novelties: The Risks of Unified Identification Number for Citizens in Brazil." Okay, the idea of the paper first arrived when I was trying to historicize some traditions in Brazil and in other countries regarding some genealogical points of the emergency of the data protection discipline. So I was trying to look into if we could see some similarities, and one of them that I found was this preoccupation regarding the unified number of citizens. We could find this theme being discussed in the 60s and 70s, in the 80s, in Germany, in France, and even in Portugal. So what I was trying to look into is if Brazil was trying to discuss or was discussing the same topic at that time. So I found that yes, we were discussing this, and even the first project of data protection law in Brazil of 1977, these discussions were being explored in the justification of the project. The first part of the paper, I tried to put this environment in dialogue, and also making some citations of other experiences. I may quote the experience of Portugal because it's a similar environment of living or in a dictatorship, and when Portugal was living the dictatorship and creating the new constitution of 1976, they created explicitly constitutional provision prohibiting the state to create a unified number to unify number of identification for citizens. So I tried to create this parallel environment between Brazil and these other countries with one objective. Because in Brazil at that time, we were living in a dictatorship with a lot of authoritarian initiatives regarding informational systems. So what was for me surprising, trying to create this historicizing process, was that today, in 2025, we are dealing with the process of creating, you may say, unified number without too much resistance. We already had a lot of internal system of states reprogramming itself to operate in this formula. So at the moment, we had the federal government and the sub-state level working with this unified number. And what I'm trying to discuss in the paper is why in the 70s, when we are living in a dictatorship, we had a lot of resistance, like technical resistance, legal resistance, and even in the public sphere, we had discussions about that. Even a famous writer, Ukrainian, Brazilian writer, Clarice Lispector, she wrote a small story called "You Are a Number" in 1971, just to illustrate that at that period we had a lot of resistance to that, and today is something that is just passing in a way without too much discussion or resistance. Why I try to put this in parallel? Because even today we live in a democracy state, but even living in a democracy, we had a lot of different kinds of violence and using these digital systems to perpetuate that. Two examples I may quote to situate my preoccupation is during the last government, we had a constitutional action that tried to explore an internal movement in a constitutional action that the state were trying to create a dossier regarding professors, public officers, and others civil rights movement regarding the anti-fascist movement. So the surveillance agency created a dossier regarding these people and using the unified number of citizens and that is connected to this broad systems. So this is just what we may say the type of iceberg. And the other one is regarding, we had a lot of small reforms that they are interrelated. And today, there seems that small projects, reforms that are not explicitly associated, but in fact they are using for another purposes and using the data for other purposes that in the beginning was not established. For example, they just created a new systems that can be used for criminal purposes. So yeah, this is the main objective of the paper, to try to situate this debate and to create, in a way, a parallel between the 70s, that we are living in a dictatorship and we had this kind of resistance, and today environment that we had a broad data, you may say, scholarship, and it is considered data protection is considered a fundamental right, and all culture of data protection in Brazil, but at the same time, not so much were spoke about that. So besides some of the main risks that we can call centralization of state, cybersecurity issues, and you may say, the excessive asymmetry power that exists between state and citizen. The purpose was just to, put this discussion in the academic field and try to get attention to it. I'm sorry I couldn't speak really well because of the microphone, and if I couldn't express myself with more clarity, I'm sorry. So thank you so much for the attention. Yeah.
Okay, first, a couple of questions for the speaker, first speaker. If not, I have one. You mentioned that you notice a significant difference in the amount of resistance in the 70s versus now. What is happening regarding that unified number system? How do you observe this? Did you see, how can you make this harder as to empirical evidence that it is less there?
Yeah, the main empirical, you may say, data that I tried first to look into was articles in the academia, and also constitutional action that were trying to create this resistance. We had a small constitutional act judged in 2022, 2023, but they did not explore these situations regarding the unified number. They just explore how this big system is being created, and they create some criteria to the state that the state must comply with. But like it's commonly said, Brazil is creating like a monster and feeding that monster, and afterwards just putting some small and formal restraints, you may say.
Because you could say, looking at from as an outsider perspective, if there's one country that is, for example, at least resisting big tech, not allowing X to operate at a certain moment, as long as they don't adhere to the law, which is quite exceptional, and not many countries dare to do that. You could say on that level at least, it's another level, it's another issue, of course, but our political rights of Bolsonaro or other issues, there you see at least some resistance, you could say.
Yes, I agree. But in this specific point, I couldn't find it. Of course, in this macro relations, yes, but this small, that seems small, that is unifying the number of citizens, I couldn't find it. Mm-hmm. That's why.
Yeah, indeed. So there's indeed a difference, you would say. Okay, so thanks again. Applause for the presenter, please. I would now give the floor to the next presentation. You have slides?
We have slides.
Yes. There.
May I try it first?
Yep.
Yeah,
it works.
Perfect. Thank you. Good afternoon. It's a real honor to have an opportunity to present our joint work with Professor Yücedağ here today, which I mentioned before. We are focusing on the data minimization principle in EU and Turkish data protection law. And let me start by briefly outlining our presentation. I will briefly introduce the focus and the motivation behind our study by an overview of the legal framework in both EU and Turkish law in Turkey. I will then highlight the core of our analysis, the reasonably be fulfilled by alternative mean tests, which is we consider a key element of data minimization principle. Then my co-author will later walk through the key case law and comparative insights. Finally, we will offer some reflections on the broader implication of our finding. At the heart of our study, as I mentioned, lies a simple but critical question, as you can see on my slide. Should data controllers be reasonable for safeguarding fundamental rights through data minimization, even against the wishes or, let me say, consent of the data subject? We argue that data minimization is not just a technical requirement, but principle that protects autonomy and human dignity. While consent has long been seen as a cornerstone of data protection, it cannot justify all data processing. Even if consent is explicit and freely given, processing must still meet the standard of fairness and proportionality. So our study explores this tension between individual autonomy and structural safeguards in law. So starting point of our analysis, as I mentioned, is the shared legal framework that underpins the data minimization principle in EU and Turkish law. As shown on the slide, both the GDPR and the Turkish Data Protection Code include similar formulations, each requiring that data be relevant, limited, and proportionate to the processing purpose. Although the language differs slightly, the substance of both provisions imposes the same obligation. That is, the data controller must ensure that the personal data they collect and use are strictly tailored to the intended purpose and nothing beyond. This similarity is not a coincidental, actually. Turkey has made deliberate efforts to harmonize its data protection regulation and data protection regime with GDPR. Most recently, in 2024, amendments brought Turkish law significantly closer to EU model, particularly in areas such as transfer of personal data abroad and regulation of sensitive data. This alignment effort, reinforced by the medium-term plan program, make a comparative analysis both timely and meaningfully, especially in understanding how similar rules operate with different legal systems. Now that we've outlined the legal framework, let's turn that what lies at the heart of the data minimization principle, the meaning of necessity. One of the most important aspects of data minimization principle actually is the idea of necessity. This involves a concrete question. Could the same purpose be reasonably fulfilled by less intrusive means? This test, although not always explicitly named in legal texts, is part of the proportionality assessment following adequacy and relevance. Our focus, as I mentioned, is on this third stage because it's where the legal duty to justify data use becomes most demanding. Controllers must actively consider whether collecting or using less data would still serve their legitimate purpose. This approach discourages defaulting to invasive processing simply because consent is obtained or because it's operationally easier. The alternative mean tests act as a safeguard, ensuring restraint and encouraging privacy by design. With that framework in mind, I now leave the floor to Professor Yücedağ for the case-based part of our analysis.
Thank you, Beyza. I will try to shed some light on this theoretical framework my colleague has just explained by bringing to your attention some cases from Turkish Data Protection Board, courts, and some other European data protection boards. So in Turkey, actually processing biometric data and its implications is not just a theoretical or hypothetical issue. For some time now, the use of biometric data still is, quite widespread. As a result, the Turkish Data Protection Board has issued several important decisions. In one significant ruling, the board ruled that using biometric data was disproportionate for ensuring routine workplace safety. So the biometric data of employees were being processed in this case, and the board found that the alternatives, such as RFID tags, magnetic cards, or SMS-based authentication was possible and were actually sufficient to achieve the aim. Therefore, biometric data processing in those cases were found to be unlawful. In a similar case, but this time it was about access to gym, and the members of the gym were obliged to consent to the processing of their biometric data. Again, the Turkish Data Protection Board found this processing to be excessive and disproportionate. Nevertheless, the Turkish court does not share this approach in its entirety. In contrast, Ankara Regional Court of Appeal adopted a different approach in a similar gym case. There, the service provider had introduced biometric access control instead of magnetic cards and relied on a contractual clause in the membership contract. The court, in this case, emphasized that it's the provider's contractual right to implement these security measures and held that the unilateral change clause was not an unfair term. As you see, actually, this approach reflects a purely freedom of contract perspective rather than a data protection-centered analysis, and largely overlooks the effects of biometric processing on the fundamental rights of the data subject. There are some also European cases, Court of Justice of European Union. It's about video surveillance. In this case, after failure to maintain safety of the premises by magnetic cards and intercoms, there was the installment of video surveillance to prevent persistent vandalism and theft. According to the court, the surveillance system was limited in scope. It was only targeting the shared areas. But the court also further declared that there's a need for further safeguards, such as restricting recording time. So the spatial limits was not enough. There were also needs for some temporal limits. In a different but the same understanding, a common point is again, is that the obligation to explore and exhaust less intrusive matters. And we see this in the Irish Data Protection Commission's 2 decisions. These cases involved the identification by ID verification, by the use of a photo ID. In the first case, DPC found that there was no breach of data minimization principle because the data controller, Airbnb, has exhausted the alternative methods to verify the identity of the data subject. But in the second case, Airbnb this time did not exhaust the alternative less intrusive means, directly sought for a photo ID. And in the second case, the PC found that there was a violation of data minimization principle. So we see that in all these cases, a common issue has been discussed. It's that the obligation to test less intrusive alternatives before resorting to more invasive forms of processing. Now at this point, let me raise question. Does the situation change when consent is the legal basis for processing personal data, especially sensitive data like biometric personal data? In this case, is there still a duty for the data controller to explore less intrusive alternatives? The answer might be seen as very straightforward, but it's not as it seems. One approach is that the state's protective role is not just limited to shielding individuals from third-party intrusions, but also from the actions of the individuals themselves. So data protection law, therefore, inevitably incorporates some paternalistic safeguards, and data minimization principle has an important place in this context. This approach is affirmed in several decisions by the Turkish Data Protection Court. In this gym access case, one of the decisions related to gym access case, members were actually given 2 options, either to enter the gym by magnetic card use or by biometric data, hand scan or fingerprint scanning. Despite the choice, despite the explicit consent provided by the data subjects, the board found the biometric processing excessive and unnecessary. The presence of less intrusive alternatives made the use of biometric data disproportionate according to the court. even in the face of a valid consent. A similar debate played out in Poland, and a school used fingerprint scanners in the cafeteria to confirm whether students had paid for their meals or not. In this case, parental consent was obtained. The students could still opt to use their name and contract number instead of agreeing to biometric data use. The Polish Data Protection Authority, likewise the Turkish Data Protection Authority, indeed found this disproportionate. However, the courts took a different stance, ruling that consent renders the data processing lawful, and the supervisory authority cannot override this by pointing to alternative methods. The Supreme Court even added that reasonable alternative criteria is based on a cost-benefit analysis. So they evaluated the alternatives primarily in material and operational time. So they took into account the duration of the school break and how efficient could it be to confirm whether students paid for their meal or not. And by taking this into account, they said, okay, this processing of biometric data is not disproportionate. However, to my opinion, this overlooks the broader legal and societal implications of this data processing, especially its effects on fundamental rights. Moreover, the risks on the minors. So, as final reflections, we see that biometric technologies are becoming more and more common and is used for even, it's more convenient. For example, some airlines companies want to install biometric data processing activities to make it more convenient for their passengers to use their lounge and so on. In that cases, we must ask, is the use of biometric data truly necessary or merely convenient? Is the law gonna allow the more convenient? Should the consent alone be able to justify such intrusive forms of data processing? I believe the answer should be no. Data protection law must continue to enforce clear boundaries that even consent cannot erase. Otherwise, individuals will be left unprotected against excessive or unnecessary data use. Thank you for your time. And
thanks again for another interesting talk. Questions? Yes, at the back and there.
Thank you for the speech. Okay. My question is based on the Article 28 of the Turkish Data Protection Law. There are the list of exceptions, and they say that, oh, based on this, that like the public benefit or this kind of stuff, there are the exceptions. And the government tends to go for generally interpreting, like the broadly interpreting this kind of like exceptions to use the biometric data in Turkey. And with the CCTV cameras and with the AI coming and facial recognition and also emotional inference while they are seeking like whether there will be crimes can be committed based on the facial expressions of people. Do you think that this law, like Turkish data protection law and the relevant like law, will be able to be enough to not being bypassed, or or the government would just use it?
very difficult question. The national security or police enforcement is also a bit of a difficult issue, I think also in Europe, because like national security is excluded from the scope of GDPR. It's up to the national laws. And for police use, there is another directive for the police to process personal data. I think it's a gap under Turkish law, the exceptions to the law, the derogations from the law. And it's really urgent, I think, to make a change in the law and to cover these areas, because if you do not have a personal data protection law assessing the general principles, or at least settling the general principles, then you do not even have data security rules applying to this. Also, we have in Turkey that some laws regarding the police and the security of the data is provided there, but applying general principles and so on is not really possible. But I'm not sure if that kind of change amendment would come into life in close future, despite all the official documents stating that we will get in line with GDPR every year at the last quarter of that year.
May I add something? At the end of the day, thank you for the question. I totally agree with my colleague, Professor Yücedağ, and I would like to add that, and I would like to emphasize that data protection is also as a human right in our constitution, stated in Article 20, and our constitutional court and our also data protection authority emphasizes that even if it's this data processing not in this fall in the scope of our code, but also is a human right, so you need to seek the balance between the individual right and the public order, as we can state it and labeled in law as a proportionality test in human rights. So, in paper about the genetic and biometric data processing for our, which is published from our data protection authority, stated that clearly that even if our code is not, even if this data protection not fall in our scope of our code, it's in any way a human right, so you need to take some precautions and you need to follow the requirements of human rights and the proportionality test.
Yeah, my question is actually short. It's kind of a remark and a question. So I think that's a really important issue, because we see explicit consent as like a free check. If you have a consent, you can do anything, but it's actually not true. But my question is this something that you can see in court cases in Turkey? That is something that like people see that like a free check, or is it like something that in court decisions taken care of?
I don't think we do have a lot of court decisions regarding that.
Or, you know, decisions from the DPA.
DPA, I think DPA looks into it, like really if the DPA apparently does not see consent as a form of a like compensation, a remedy, something's compensating the missing element of a general principle. So it's very clear, and I think it's a very good example because it's a very strong point to defend. Not, I think every DPA could do it, despite the clear choice of an individual, you limit their ability, and you can be criticized. It can be easily said that, but it is the authority of this person. It's the right to self-determination of this person. Why do you intervene? Intervening to this position is actually disproportionate. One may easily criticize, I think, the position of data protection authority because we do limit the person's autonomy. But the courts, I think, will see it differently. I think they will see it more from the contract law perspective, and they will not really look into the fundamental rights effects on it. They will say, what is the harm in it? I mean, it's a contractual relationship. If you don't want to use that, go get it from somewhere else. But this is not how we do the assessment. But I think the court has already done this in such a way.
Thank you. Okay, a nice applause again for the presenters. For the third presentation by Evrim Görmüs.
Yes.
I said it right, luckily. So, please.
Okay, thank you very much for being here. Today, I will mainly talk about the implications of AI cooperation between Israel and United Arab Emirates in the aftermath of the Abraham Accords from the perspective of digital authoritarianism that I already said. For those of you who want to refresh their memories about Abraham Accords, it was signed in September 2020 and initiated by the Trump administration, right? So he celebrated this. Now we are bringing the peace in the Middle East and etc. Okay. Oh, I'm sorry. Yeah, I need to hear. And it is still, of course, it's still the case. It is the normalization agreements between Israel and several Arab countries, first with Bahrain and United Arab Emirates, then Morocco and Sudan joined. And emerging technologies, it was in various fields, but especially emerging technologies and AI cooperation became the central focus of Abraham Accords and its afterwards. And as I said, it was celebrated as a kind of like bigger thing in the Middle East. Things will have changed and etc. But I argue that it somehow like increased the growing trend of digital authoritarianism in Middle East. So like when we look at the origins of this phrase, digital authoritarianism, right? We keep using this term a lot, and it seems so. It was first coined by Erickson and Lee Makiyama in 2011, and then it became more popular after Freedom House report in 2018. And those earlier work defined digital authoritarianism as authoritarian regimes' use of digital technology to surveil and repress. But this, as you see, is very like regime-centric and state-centric definition, and it was then criticized by many scholars like Glassius and others, and they suggest not only focus on regime types, but focus on practices. Then we can observe somehow practices which infringe on autonomy and dignity of the person. So, and this, in my work, I also adopt this practice-based approach to, and then in that way we can see the complicity of corporate and also other actors other than state in diffusion of authoritarianism throughout the world, actually, not only, of course, the Middle East. And so, in the case of my presentation between Israel and United Arab Emirates, you can also like adopt this to many places, actually. Big tech companies' commercial interests align with authoritarian regime survival interests. In the case of United Arab Emirates, of course, this survival need is very important after the Arab uprisings, and there were some like dissents and opposition movements. And United Arab Emirates, starting from early 2010, using such repressive digital technologies to suppress opposition movements. And there was this type of state and corporate partnership emerged, and it was very distinct and unique. And through this transnational public-private network, such technologies are adopted, intensified, and transcend the special boundaries of the state. So like here, I'm talking about the diffusion of authoritarianism through various ways. And so transnational dynamics of digital authoritarianism also requires to understand the rapid growth of global surveillance markets. As you see, like from 2011 to 2013, this market increased substantially, and in 2030, it is expected to reach more than $250 billion. And when we look at where those companies are located, I mean, we can talk about, according to Privacy International latest report, we can talk about 600 surveillance companies around the world. And majority of them, as you see, are located in so-called democratic countries, 90% of them. And only 10% is located in some authoritarian countries. And here, Israel, somehow like the rising star, and it became like very important global supplier of advanced technology, particularly in AI-based cybersecurity, surveillance, and spyware industry. And here are some like statistics about how Israel is doing great in this field. Like in 2016, for example, Israel had the highest number of surveilling companies per capita globally, representing 20% of the worldwide market. And then, I mean, high-tech export reach substantially, and it kind of like now it's almost 50% of their its total export, and etc. Here, what is more important, I guess, Israel successfully used this private cyber weapon sales as a political leverage. And as you see from some quotations from Netanyahu and chairperson of the Israeli Space Agency, back in 2018, Netanyahu himself admitted that yes, Arab world somehow like admires our technology, and this can be the way of like normalizing relations. And he also like say that even like the peace with Palestinians will be somehow like connected with that type of like relation, technical relation between Israeli and Arab countries. And also this Isaac Ben Israel, chairperson of the Israeli Space Agency, admit that spyware sales is a legitimate tool of diplomacy, nothing wrong with that, and then it makes us somehow like closer. And I'm not sure if you are familiar with this company, Pegasus, Israeli spyware company by NSO Group. And so kind of like many scandals actually were like revealed by the New York Times and Citizen Lab and other NGOs. And it was already like revealed that since 2013, way before the like normalization, even in that like years, United Arab Emirates was not recognizing Israel officially, right? And it was revealed that since 2013, United Arab Emirates used that technology, Israeli technology, to suppress their opposition. Also, like tap into communication from like senior Qatari officials, Saudi royals, Lebanon's prime minister, journalists, human rights activists, even Emirati royal family members like Princess Latifa and etc. And so when you look at the literature, actually, this acquisition of Israeli surveillance technology is cited as a key factor in UAE decision to normalize the relations with Israel. And as I mentioned before, this growing appreciation of Israeli technology somehow like accelerated by the regime concerns over stability, and also some like also other concerns about Iran's cyber threat attack to United Arab Emirates and Saudi Arabia. And then after those years, cross-border technology exchange increased deepened under the Abraham Accords. And those are some like, as you see, how like things are developing between Israel and the United Arab Emirates. Mubadala, the sovereign wealth fund of the regime, United Arab Emirates regime, invested like heavily in Israeli surveillance industry since then. And then many close relationships emerge that I can talk about. But what is more important, I guess, this peace agreement, normalization agreement, and we all know now like there is such situation like occurring in Middle East. But from the very beginning, actually, of course, some critics said that this is not like bilateral relations cannot solve any of the problems of the like Middle East. Like I'm talking about Palestinian issue, of course, and this Abraham Accord is criticized as illiberal peace. And Dana Al-Kurt, you can find her like a very good piece on Abraham Accords. She mentions, as I said, Abraham Accord as illiberal peace because it maintains original conditions of the conflict, right? It not do anything on the Palestinian issues, just bilateral normalization, and facilitate authoritarianism through material mechanism and discursive mechanism. Here, mainly, I talk about material mechanisms, right? Because bolsters through cross-border technology exchange, strengthens states' repressive capacity by provision of repressive technologies to normalizing countries. But this was done without any transparency and accountability, right? Then it's somehow like we see unregulated transfer of surveillance technologies and expansion of surveillance expertise across the region. And I also mentioned this, how this bilateral normalization was very harmful for the Palestinian problems from the very beginning. And from the very beginning, as I said, critics said that this will sideline Palestinian issue. And for example, when you look at the somehow groundbreaking project of Abraham Accords between Israel and United Arab Emirates, United Arab Emirates Israel Business Council Economic Activity, for example, plan to construct a high-tech zone in occupied East Jerusalem. In that way, somehow United Arab Emirates contribute to Israel de facto occupation of Israel de facto occupation of Palestinian territories. What we have seen is special control of economic and technology, political tool, and repression. And so, what's happening now, right? Because it was before the Gaza war, and the war starts in 2013, and this is somehow very, I guess, important thing to look at. When you compare the last quarter of 2022 and 2023, Israel's total export with the rest of the world decreased more than the Abraham countries. So what was that? It was about 17% of decrease with the rest of the world, but only for around 4% of decrease with the Gulf countries, Abraham countries, let's say. And so this process actually continued to prioritize tech and economic relations, as you see. And there are also different, of course, rationalities behind this decision. When you look at the interviews of UAE leadership, they said we need that kind of relation to support Gaza. If we were not there, they will be even worse. That kind of things. Also, United Arab Emirates wants to participate in post-war rebuilding in Gaza. And Israel, of course, is happy about that. And they, especially tech elites, try to frame this war as the war between moderates and fanatics or extremists, and technology can play a good role for them to kind of bridge this too. And so what will happen next? I wish I can provide more positive picture, but questions remain very serious, right? So and new Trump administration also want to expand Abraham Accords to Saudi Arabia. So it is the biggest plan actually, but it's not that easy. Also to Libya and etc. But I try to said that actually the pursuit of this type of technological collaboration embedded within distinct political and economic structures will not solve anything. Just further entrenches existing power imbalances and exacerbates authoritarian practices in the region. I can finish here. Thank you very much for your attention.
Okay, questions? Nobody? I had a question. You mentioned the notion of digital authoritarianism. So would you say there's a kind of a scale in the literature on what is the tipping point of what parameters define when you enter this kind of perspective on a governance structure in a country?
Yeah, the use of these technologies to surveil and repress the opposition, so-called opposition, and to control society for any purposes. So mainly, and this purposes is not good, right? That's kind of control, and then sometimes to kill them or kind of to listen to them and etc. So it's very various and broad.
Yeah, indeed. So yeah, and very relevant. I see many how this is enforcing all this kind of technologies, also by companies like Palantir.
Yeah, and also like we need to recognize the role of tech companies in that diffusion of authoritarianism, right? So like all regulations, so I'm not a law person, but like all regulations and etc. should also, they need to like accept their responsibility at least.
Absolutely. Thank you again. And let's go to the last presentation of this session, Beatriz de Souza. The floor is yours.
Thank you. So as you can see, we are going to change the subject a little bit to focus not on data protection specifically, but on competition policy, to present the lessons learned from merger control in digital markets and their contributions to competition in AI markets. A brief overview of the content. I'm going to introduce the article, present the lessons learned on concentration in digital markets, then compare digital markets with AI markets and explore the possible roads for antitrust enforcement in this scenario before concluding. So merger control in digital markets has been criticized in the last 2 decades for underestimating the competitive harm of acquisitions by dominant digital platforms. And now in the context of a new context of emergence, relative emergence of AI markets, there are questions of whether big tech is also going to capture this nascent market. So we decided to compare the lessons learned on this experience in antitrust and see if they apply to AI markets. Before we start, it is important to clarify what we mean by AI markets. There is a tendency to focus on development of foundation models, but it is a broader term for the purpose of the article, so it also includes certain critical inputs, development, release, and deployment of AI models, regardless of end use. With that in mind, the main lessons learned about concentration in digital markets were first, that data is a very important competitive asset and barrier to entry, so companies can use both personal data from users and non-personal data, usually from businesses, to enhance their services, creating feedback loops, which tends to increase their market power. This was overlooked in the beginning of the digital economy, because in the beginning it was not clear when there were mergers among companies that didn't seem to be competitors acting in the same relevant market, that there would be damages due to the control of access to data. But now that this characteristic is more clear, there are concerns about foreclosure due to the concentration of access to data. Other relevant barriers to entries were economies of scale and scope and network effects. Another issue discovered is the need for new theories of harm. This is perhaps more interesting for privacy and data protection, because the issue was that traditional antitrust theories of harm tend to focus on price, but concentration in digital markets often doesn't affect price. It affects rather consumer choice and privacy, so evolving theories need to take that into consideration, as well as other harms, such as harms to innovation. Market definitions also tend to be more complex in these scenarios, and there are oligopoly scenarios. This is a term coined by Nicolas Petit to refer to a situation where firms which are dominant in certain sectors, they become competitors amongst themselves in new sectors, such as the AI foundational model market. And precisely due to this dynamic of big tech companies competing amongst themselves in the AI market, digital markets and AI are currently intertwined, also because they share the same key inputs, which are digital infrastructure and data. But we should still analyze whether the same lessons apply to this new market. So on the one hand, we do have similarities. There are leverages conferred by the presence in digital markets to act in AI, namely the access to data from users, which configure economies of scope. And there are barriers to entry, which are actually more relevant in AI because of the high costs for infrastructure. But on the other hand, there are factors that differ. So economies of scale and marginal costs, which were very important for concentration in digital markets, don't appear to be in AI because the cost per use here is very relevant due to the need for compute power, which is not only financially costly, but also in terms of energy and water consumption. Feedback loops and network effects were very important for digital markets, but don't seem to be the case for AI. There is a very specific web of players and partnerships, so the acronym for the biggest firms acting in digital markets had to be adapted to include NVIDIA, And these companies are at the center of this market, and they also have very close relations to the new startups via investments and partnerships. They also have very important relationships with the cloud computing sector. And there are different competitive dynamics. So if we adopt the taxonomy of foundational models proposed by Shrapple and Pentland, we can distinguish them between general public foundation models, which can either serve general purposes, so think of ChatGPT and Gemini, or be domain-specific. There are also ecosystem foundational models and personal or institutional foundational models. So these two, they tend to be pre-trained with other foundational models, but then fine-tuned with specific data. So for ecosystem foundation models, the example would be a model developed by companies in the same industry, and they share that model. And for personal or institutional foundation models, they serve only specific users, which can either be individuals, governments, companies. And this is important here because it makes the scenario more unclear if we compare it to digital markets. So if for general public and general purpose foundational models, it seems that big tech is already capturing this market, the same is not very clear for the other cases because in fine-tuning, new niches may be created for new companies to act. So in this scenario, the possible roads for antitrust enforcement are still developing. Antitrust authorities have been analyzing mergers involving AI for some time now, but like in digital markets, preoccupations about concentration tend to appear with time. So for example, the European Commission approved the acquisition of Mellanox by NVIDIA in 2019, but last year it showed more preoccupations about the attempted acquisition of ARM. The acquisition was ultimately canceled by the parties, but it does show that, like in digital markets, the preoccupations tend to come with time. In Brazil, the Brazilian Competition Authority, CADE, also analyzed various mergers involving AI and approved them, but it did show more concerns about this market last year when it sent notifications to Microsoft, Google, and Amazon requiring information about their partnerships with startups to see whether they should have been notified under merger control and whether they are likely to cause anti-competitive effects in the Brazilian market. But no decisions have been made so far. Many authorities are studying this market, but no antitrust measures are yet in place. So for example, the French Autorité de la Concurrence issued an opinion about the functioning of the generative AI market. The European Commission, together with the CMA, the FTC, and the DOJ, issued a statement on the competition in the generative AI foundation model market. And in the beginning of this year, the FTC published a staff report on AI partnerships and investments involving developers and the cloud computing sector. In very general terms, their main findings are that there are preoccupations about the foreclosure of the market due to control to access to key inputs, so namely chips and compute power. But on the other hand, the partnerships may also present efficiencies insofar as they may give access to inputs for startups. These issues are still being discussed. There are different views being debated. So for example, the OECD published a working paper where it suggested that we should rethink the balance between under-enforcement and over-enforcement in the antitrust when it comes to AI to avoid the foreclosure of this market. On the other hand, Shrapple and Pentland propose a different view. They propose an innovation-first approach in merger control, so really putting forward the efficiencies related to innovation and exemptions to open access and open source models. So just to conclude, we should still continue to study these issues because conclusions are very hard to make when it comes to antitrust. We have to see if the efficiencies are going to compensate the potential harms. There are important lessons that we can learn from the digital markets experience, namely that there are shortcomings in traditional antitrust frameworks, and other factors such as data, talent, and technology plays a significant role, not only market share per se, when it comes to acquiring new firms, but on the other hand, we should consider the specific characteristics of the AI market. Thank you very much.
Questions? Yeah.
Thank you. When it comes to competition law, when you make an examination, the first thing you have to do is define a market. And it's really hard when it comes to emergent technologies because you don't know what's the conclusion and what it's going to be used for. So what I wanted to ask is, one, is it possible to, or is it too late, making a market definition when it's adapted? Because when it's used, it's adapted, and it can be too late for making an action. And the second question is about declared acquisitions, because when a company sees a competition, you just buy them, And the current competition law tools are sufficient to just deal with that.
Thank you. That's a very good and very hard question. That's the main difficulty. So the same thing happened in digital markets. That's exactly the concern that competition authorities may not see when a firm that's being acquired is going to be a competitor. So I think that the experience with digital markets makes it clear. So maybe now antitrust authorities have more tools to deal with that. On the other hand, they also they are very careful in doing that because of what was in the slide, the error type 1, type 2 balance. So we are having to see and wait if they are going to rebalance that. There is a tendency to maintaining the idea of avoiding at all costs the error of over-enforcement. In practice, I don't see that changing very much, but there are discussions so that it is a possibility that the enforcement is going to tend to the other side. But of course, it depends on competition policy and from country to country. So I don't know if I answered to all of your questions.
There's no answer to that question, actually. So.
Yes, exactly.
Thank you for the very nice presentation. I wanted to ask in relation to the digital markets. It's a very concentrated market with very specific players per category of online platforms. Right now we're seeing, for example, in the search engine domain, that a lot of people turn to generative AI instead of using an online platform, a search engine provider. So we see that some people go from Google to ChatGPT. At the same time, we see Google using Gemini AI. So I wanted to ask if we foresee, or do we see right now, any disruption in the market in the digital markets by the incorporation of AI? So if these highly concentrated markets are going to be disrupted and maybe rendered less of an oligopoly because of the incorporation of AI? Thank you.
Thank you. That's also a very great and hard question. So the problem is due to the leverages that these firms already have in digital markets, it is possible that the AI market, that is exactly the concerns of the authorities when they are studying this market, that this is going to maintain the same structure. So the main firms, as you said, the oligopoly acting in digital markets would just maintain itself in AI markets. So for general purpose and general public AI models, this seems to be the case, but we need to see if this is going to be the case for other purposes. So when you have fine-tuning and more specific tailored applications. So thinking about search engines specifically, since we are already coming from a market with a very very close, already formed structure, I don't see that this could change that much. But when it comes to other markets that are still going to be nascent, that's where this is going to be possible.
Thank you. I really like also the perspective. It's kind of a political economy perspective, of course, what you're doing and looking at follow the money. And it was an interesting article, an internet policy review by, what's her name, Agata Balayin and Seda Gerses, about how AI should be regulated differently and looking more at the agile production environment surrounding it. So especially in place of only looking at the end phase, the AI, it's a much deeper issue to regulate it better and it's a bit in line with what you were telling. So I would really advise you that piece also. So let me reopen the floor for all the panel members and have questions regarding any of the presentations we have seen. That's now the moment, if there are any, because I do see some line in the different presentations, what you're talking about. I've made some notes about it. I think what you see and coming back in each of your presentations is there's a bit of a power concentration where regulation is not really taking enough teeth, of not enough force to avoid this power concentration. And power concentration by states, regimes becoming increasingly authoritarian and using these tools, surveillance companies becoming very powerful and being used in accords, Abraham Accords and others. Big tech companies becoming, what you mentioned, becoming in digital markets and how they should be regulated or are not sufficiently regulated or not used from the perspective as done with other regulations. And all at the expense of fundamental values, fundamental rights, public values and citizens and civil society. And I think what we see here among is that also how digital technologies and also function creep to some extent, so using it for something, but then start using it for purposes they were not meant to be, and in a sense also then misused, against some fundamental rights and also seeing how then economic agreements, legal uncertainties, like what was mentioned also, and also diminished resistance, that people don't care anymore. The reasonable expectation becomes differently what you can expect. First the past, you see this also now in resistance against regimes becoming authoritarian. People are suppressed and people have a lack of resistance sometimes in this regard. So I do think it's a nice combination, what you've been talking about together in a sense. Are there any final reflections which you would like to make? Otherwise we can close the session, close the panel now. Yes?
I have a question about the digital authoritarianism because, what we've seen, like in Turkey, that somebody wanted some tweets to be deleted because it was against their policy, and it was deleted. So do you think it's a problem of like a democracy, or is it becoming more private? Because private sector is coming really merged with, the governments right now. So do you think it's like a problem of democracy, like or is it a problem of private sector?
I guess both, but generally the problem of democracy, because in functioning democracies, everyone's interest should be protected, right? So what we have seen is the dominance of big tech technologies, private sector here. And I was trying to explain in the context of Middle East, but in other parts of the world, the same. Their interests are now converging, right? So for example, in Turkey, now with Elon Musk and etc. So some personal relations are also in the case. So I guess problem of democracy, I will say. And problem of democracy.
That's the question. You mentioned in your slides also refer to Polish case law. And so where they talked about how they, I would say, disregarded this data minimization issue. Knowing that Poland has gone through a very strange period where a kind of, I'm not sure to call it authoritarian, but at least attacking media, attacking the legal system. Is it in that period situated where judges were appointed and there was a big issue with independence and stuff? Is it from that time period that you have this case law? Was it?
I need to check what was the time period of the decision. I think it's a new one. Yes, it's not.
It's not from that period. It's a new one. No. So,
I do think it's quite a liberal position, actually.
Okay. Yeah.
Rather than being conservative to.
Yeah. than being...
It's based on the contractual freedom, again, I think, and it's 2024.
Yeah, okay, so it's quite recent then. Okay, so that's a general, okay, no, I thought it was because then now you see that the Polish government is trying to establish more independence again for the legal system, and so, okay. Okay, we're mostly out of time, except when there would be a final question, reflection, remark, then I would like to thank the panel again for the nice presentations, and see you soon in the next panel. Thank you again.